Hello, my name is Jacob Spur, and today I will be discussing the importance of the right to privacy and what that means for intelligence-led policing. Intelligence-led policing, or ILP, is a method used by law enforcement agencies where agencies collect intelligence while trying to solve crimes in order to use the intelligence collected to convict criminals and to try and stop future crime from occurring by analyzing the source of the problem. The definition that I have on the slide is a very good one for what ILP is and what law enforcement agencies are trying to achieve by using ILP. So what is right to privacy? According to Cornell Law School, a person's right to privacy is the right against undue government intrusion into fundamental personal issues and decisions. While the right to privacy is not mentioned within the Constitution of the United States, several important legal decisions have confirmed citizens' right to privacy. 3 of these legal decisions include Eisenstadt v. Baird, Roe v. Wade, and Lawrence v. Texas. While each of these cases do not give an exact list of privacy rights, they do limit the government's ability to reach into its citizens' lives. So, why does right to privacy matter to intelligence-led policing? Well, right to privacy is a very important issue for intelligence-led policing. Law enforcement agencies must be very careful when collecting intelligence for criminal cases and must follow the law so as not to violate a person's rights. If law enforcement fails to do this, it may be seen as a violation of a citizen's rights and may jeopardize an important criminal case. Therefore, law enforcement must walk a very tight line when collecting and storing criminal intelligence. Right to privacy is controversial because law enforcement agencies are better able to stop crimes when they can collect more information on the crimes being committed. Because of this, it is very important for law enforcement agencies practicing intelligence-led policing to collect as much relevant information to their case as possible. An inability to collect intelligence on criminal activities will limit the effectiveness of ILP and law enforcement's ability to prevent crime. Law enforcement must be able to intrude into a criminal's life in order to prevent them from committing further crimes. This is controversial because when law enforcement agents intrude into the lives of criminals, there's nothing stopping them from doing the same to law-abiding citizens. There are several laws that govern the collection and handling of intelligence by law enforcement agencies. These laws are the boundary that keeps law enforcement out of the lives of law-abiding citizens. 2 of the most important of these laws include the Privacy Act of 1974 and the Freedom of Information Act. Both are federal laws that were enacted by Congress to make the collection process for law enforcement more transparent. The laws also help to establish regulations for the handling of collected intelligence. The next 2 slides will contain examples of ILP and the right to privacy. Both examples are useful for understanding why law enforcement must be careful when trying to collect information on U.S. persons. They are also useful for explaining why right to privacy is a controversial issue in law enforcement and ILP. The 2 examples I will be discussing are the Supreme Court cases Griswold v Connecticut and Katz v United States. Both examples help to list the importance of right to privacy within intelligence-led policing. The first example is Griswold v Connecticut. This case is very important in understanding the right to privacy, as the Supreme Court determined during the case that the Constitution has an implied right to privacy. This means that law enforcement must not violate people's rights when attempting to stop a crime from taking place. My second example of the controversy of right to privacy is Katz v United States. Katz v. U.S. was a Supreme Court case that determined that it was illegal for law enforcement to gather intelligence with a wiretap without a warrant. This is a very important case in terms of ILP because it states that intelligence was not gathered legally and therefore is not permissible as evidence in a court. These examples are important to the issue of right to privacy in the context of intelligence-led policing because they help to define right to privacy and why law enforcement agencies must follow the laws governing intelligence collection. These 2 examples are important because they define the argument that right to privacy is a right that citizens have and that law enforcement agencies must accommodate. These examples are very significant to the effectiveness of ILP. Griswold defines that people do have an implied right to privacy, which opens arguments as to what is considered a violation of privacy by law enforcement. Katz clarifies that only evidence that has been legally obtained may be used against criminals in legal cases. While right to privacy is a complicated issue, there are some ways in which law enforcement can help to avoid it. By better informing both agents and members of the public what their rights are, there will be less confusion and controversy around law enforcement's gathering and storage of intelligence. While education may not stop the willing ignorance of criminals, it will help to inform members of the public who are just trying to protect their own rights. Another solution to stop the controversy over ILP is law enforcement being very transparent about what kinds of intelligence they collect and how they store that intelligence. By being very open with what kinds of information are collected and how they are stored, people will be able to understand exactly what kind of intelligence law enforcement is collecting and will be unable to argue that law enforcement has overstepped its bounds with the information that it has collected. Right to privacy is a very important issue facing law enforcement agencies that practice intelligence-led policing. By understanding the issue, law enforcement agents are better able to practice ILP without concern that they have violated a law or have been perceived to violate a person's rights. That's the end of my presentation. This first slide of references are citations for web sources that I used to gather my information. That includes the quotes that I used upon some of the slides. And this second page is for the images that I used. Thank you for listening.